It's a delight to be here at Bergen Exchanges, and just to say a huge thank you to Siri, Lara, and Matea, everybody who's worked so hard to make the program come together. This session is on contesting land in plural land regimes and about traction for Indigenous rights. We have me doing a moderating and introductory job, so I'm just going to take 10 minutes, and then each panelist will have 8 minutes, and then we'll have our 15 minutes requisite for participation from the floor. And the questions that I've asked, or we're all trying to address in the panel, are the challenges and possibilities of legally plural orders, whether they enable, impede transformative justice outcomes for Indigenous peoples in the different contexts of legal struggles that everybody is working on. How courts and other institutions get mobilized in Indigenous peoples' land struggles, and with what effects, how that's changing, and how important Indigenous peoples' socio-legal battles are in challenging dominant colonial narratives on development, territory, and land. So in my 10 minutes, let me just say, Siri, can I ask you to move your legs so I can see the clock? Thank you. Perfect. I'll say a little bit about our research project, PluriLand, which a number of you who've been here before have heard me talk about before. The project's in its final year. We've got one more year to go. The case studies we're looking at are Brazil, Colombia, Guatemala, India, and South Africa. Tatiana, Namita, and Ara Carolina are part of the PluriLand project. Jorge isn't part of the project, but he's contributed at numerous points to our collective discussions, and his own work, as you'll hear, on territorial judicialization processes in Mexico is really relevant to the panel. So some of the questions that the bigger project has tried to tackle with what's the nature and what are the effects of land rights judicialization by marginalized rural groups? And here on the panel, we're talking about Indigenous peoples, and many of us are looking at exclusively Indigenous peoples, but not only in the project. So, for example, Tatiana will talk to Colombia, where you're looking at Afro-descendant and peasant communities too. How do these processes of socio-legal mobilization play out over, like, the land/territory question? Something Malcolm's going to talk to us about, hopefully resolve in the afternoon, is what do we mean by transformative, right? And we've really grappled with that throughout the project. How might we conceptualize what transformative judicialization is for Indigenous peoples and marginalized groups more broadly? And then, is there something specific to land conflicts compared to the other kinds of social and economic rights conflicts that we have looked at over the years in LawTransform? So one of our starting points for the project was whether or the extent to which codification of specific collective rights for Indigenous peoples and other marginalized rural groups in international law, in constitutional law, and in other instruments offers traction for more transformative pro-rights judicialization centered on Indigenous peoples' rights to self-determination. And why PluriLand? Well, because that pro-rights judicialization takes place in plural legal orders, right, including Indigenous peoples' right in international law on Indigenous peoples' rights, constitutional law, which in many contexts provides enhanced protections for Indigenous peoples as collective subjects of rights and rights to land. Civil law, of course, comes in, property law, secondary legislation around development, extractivism, contract law, administrative law, forest rights, which Namita will talk to us about for India, and crucially important, Indigenous people's own forms of law and governance over their territories. And so we're very interested in how those play out together, how they interact in socio-legal battles over territories. And we're not kind of replaying the old debates about whether legal pluralism is good or bad, right? It's, you know, we're not taking a normative position, it's just a social fact that legal pluralism exists, and we're interested in how those layered norms play out in these processes of judicialization. So in terms of the broader debates that PluriLand has drawn on and aims to contribute to, those include, and we've talked about these over the days, legal mobilization and the counter-hegemonic uses of law. Specifically, we've contrasted different kinds of framing through law and also different sites or courts where these battles have taken place. We've addressed some of the debates around transformative constitutionalism, about the transformative effects of judicialization. We've intersected with a lot of the debates around authoritarian backsliding and backlash and judicial politics and how that affects outcomes, and specifically around land/territory. And the debates about how to decolonize land relations and how to decolonize law, and how Indigenous peoples' conceptions of territory and land are mobilized in legal settings. So the epistemic or ontological disputes in and through law. And the last point to say, I think I'm going to run out of time, is while we haven't specifically analyzed the criminalization of Indigenous defenders within the project. We did think about that at the beginning, and then it was just, it's another project. So what we might think of as anti-rights judicialization or lawfare, but that's definitely the context in which the kinds of litigation that we're examining is taking place, right? Because these are battles over territory in contexts of extractivism, mining, agribusiness, green colonialism, and also contexts of very direct and very lethal forms of violence exercised against Indigenous territorial defenders. I was going to talk about what we did and what we've got coming out. I haven't got any time, so I'll just flag up that we've got a couple of joint articles coming out in the annual review of law and social science, and hopefully a special issue coming out in one of the critical agrarian studies journals on the work that we've done. So I'm going to stop there and hand over to Namita Wahi from the Center for Policy Research and LawTransform. Namita, thank you.
Thank you, Rachel. Good morning, everyone. Once again, thank you to Siri, Lara, and the LawTransform team for putting this together, and to Rachel, Tatiana, Anna Carolina, and Jorge, and other colleagues, Anna, on the Plural Land project. As Rachel mentioned, plural land regimes are a social legal fact in post-colonial states, and this is because of the inherent nature of colonization as a process of appropriation of natural resources of the colony for enabling economic and social development of the colonizer. But this process of colonization, which in India happened over a period of 200 years, first under the British East India Company and then under the British Crown, was met with continuous resistance by the people, by the colonized peoples, and therefore the colonial legal regimes were never able to effectuate a complete erasure of the pre-existing legal regimes. Post-colonial states did not start with a clean state. Even as they began their independent existence with a commitment to reverse centuries of injustice of colonial rule, they inherited a baggage of colonial legal and administrative frameworks that could only be reversed over time through democratic consensus, and only insofar as these changes were justified within the now hegemonic narrative of economic development that these post-colonial states, now known as developing countries, aspire to. So, in the case of India, the state control over land and resources, both under the colonial and post-colonial regime, was effectuated through a series of land acquisition laws, which authorized the compulsory taking of land belonging to private individuals and common property resources by the state, forest laws that asserted state ownership of forests and derecognized the rights of forest-dwelling communities, mining laws which asserted the right of the state to all resources in the subsoil, and irrigation laws that enabled the appropriation of commonly held water resources, so land, water, forest. However, this colonial policy met with resistance both from peasant farmers and as well as indigenous or Adivasi or scheduled tribe communities in India. Therefore, it only happened in a piecemeal and historically contingent manner. While both the agrarian population and the indigenous communities, and in the India case study we are looking at both, opposed the colonial appropriation of resources belonging to the people, there was a key difference in the opposition that came from the indigenous communities, coming from their differential understanding of land as not only an economic resource, but as integral to individual and community identity, history, and culture. Moreover, social movements of indigenous or Adivasi groups in India have articulated the rights to Jal Jangal Zameen, literally translated as water, forest, land. Within this understanding, land and water rights are not separate, but part of one indivisible ecosystem that is crucial to the preservation of the Adivasi or indigenous way of life. Another reason for the plurality of land regimes was because of the British policy of divide and rule. This not only resulted in the exclusion of indigenous communities from the rest of the population following the Scheduled Districts Act of 1874, but also led to the recognition of diverse customary inheritance regimes for all religious and ethnic communities, including with respect to land. Recognition of identity-based vulnerable groups and redistribution of land were key themes for India's emergence from colonial rule. The Indian Constitution was pioneering, transformative, not only in terms of providing special constitutional recognition for indigenous or Adivasi groups as early as 1950, but also in enshrining special protections for land rights of the scheduled tribes or Adivasi groups vis-a-vis the state and other communities in geographically demarcated tribal majority areas known as scheduled areas under the 5th and 6th schedules of the Constitution. The Constitution also expressly guaranteed to all Indians civil and political rights to liberty, equality, and fraternity, and also included non-enforceable social and economic directives with respect to health, education, labor, and livelihood rights. It also provided for affirmative action provisions for both the scheduled castes and the scheduled tribes in state-supported educational institutions and government jobs. Against this backdrop, for this project, we looked at all the Supreme Court cases using various search terms and relevant legislation to identify cases that had been decided by the Supreme Court. We wanted to see, we got about 35 cases from that. From that, we excluded cases that only involved individual claims because of, and then identified 4 cases where individual and community claims were involved by both indigenous and non-indigenous groups against displacement. And most of this displacement involved, and again, most of the displacement in India of the indigenous groups has happened because of dams, mines, and wildlife parks and sanctuaries. So we identified 2 cases involving dams and 2 cases involving mining activity from 3 different states of India. And one of the complex things about fieldwork in India, I'm not sure if that's the case in other countries, is the fact that, and that is one of the, the inability to erase by the colonial regime, is that there are so many different languages. So fieldwork was particularly difficult because each of these states has a different language and languages that we don't speak. Each of these cases involved multiple protective and displacing laws. What we found in quick summary, the common strategies of legal mobilization that we observed in the 4 cases. And also I want to mention that unlike other cases, each of these cases actually from the point of time when there was the creation of the legal dispute to the actual resolution, the period lasted between 40 to 70 years. And the common strategies of social and legal mobilization we saw were community-based organizations in each of these cases as platforms of collective resistance. Of the 4 cases, the 2 dams cases involve non-indigenous groups, and the 2 mining cases involve indigenous groups. People relied on trusted community representatives to articulate their concerns and demands. We saw a very significant role of activists and lawyers, people belonging to these regions who were well educated and connected to the networks of political, bureaucratic, and legal systems who could access governmental, judicial, and constitutional mechanisms to bring their claims against the mining and dam projects. These activists and their networks and organizations empowered the local leaders within the communities who then accessed legal systems, and there was a constant process of engagement between the community representatives and the activists and lawyers, where the activists and lawyers explained the Constitution, explained their rights to the people, and the community representatives disseminated that and mobilized. And we saw a big influence of, in some of the cases of Gandhian satyagraha, non-violent protests. Satyagraha simply means truth and non-violence, non-violent peaceful protests to put forward their claims, seeking arrest from the government, very much how like Gandhi and the leaders of the Indian freedom struggle fought against the British rule. So together they organized and coordinated, movements to resist displacement effectively. Because of the remoteness of the courts, both the High Court but especially the Supreme Court, we found that litigation was always the last resort when all processes of resistance and communication with the government, whether it was through the bureaucracy or the political establishment, had failed. And these included like your local MP, your local MLA, your local bureaucrats. The common deterrence tactics used by corporations and the state apparatus, because each of these cases involved either the project was by the state itself, or mostly it was by a private corporation to whom the state had given the land or the lease. The state and the corporations use bribery, violence, and intimidation to silence activists and community voices by co-opting the state machinery, political, bureaucratic, and the local police, and put everybody in jail at multiple points in time. And it was easier to do this in the case of dam projects because these projects were run by state and central governments. But there were also instances where the state was acting on behalf of private corporations. The government also filed false criminal cases to criminalize dissent and use local police to suppress mobilization efforts. And that increasingly in my work on land rights over the last decade, I begin to see that on the ground, the whole distinction between civil and political rights and economic and social rights completely disappears, because the most important right that you need, and it relates to the conversations we had on the first day, is the right to free speech. The remoteness of these sites from courts, and the legal costs of access to lawyers, courts, and the language of the law and the courts. Because again, there are different languages that are being spoken in different parts of the country, but there are different languages that are spoken by the tribal people, and, and the language of the law itself is a barrier. To conclude, unlike litigation with respect to other social and economic rights in terms of the judicialization of these conflicts, land litigation has a vast time span for both individual and community claims. The average time span is, for individual claims, is 20 years. For the cases that we were looking at, individual and community claims, was between 40 to 70 years. And this involves, there is simultaneous contestation on the ground, there is social mobilization on the ground, there is contestation in every site. It's not that they are preferring one to the other in parliament, state legislatures, constitutional commissions, high court, Supreme Court, everywhere. The necessary conditions for success that we see across the 4 case studies are social mobilization, unity and organization amongst the communities, and activists and lawyers who can present the claims of the communities through representations to politicians, bureaucrats, commissions, and the courts. This is the necessary condition for success. The quality of legal arguments, progressive lawyering, focusing on legal rights and historical claims, and emotive arguments as opposed to cost-benefit analysis are likely to win. And ultimately, it is the faith of the communities in their rightful claim to the land and ability to resist bribery, intimidation, harassment, violence, even to lay down their lives for the success of the community's struggle for justice. What we also found that is in the courts, the development discourse more often than not trumps the right discourse, especially when 2 rights are pitted against each other. For example, in the dam projects, the right to drinking water versus the rights of the communities to land, water, forest. But when communities remain dogged in their struggle for their land, water, forest rights at all sites of contestation, then justice can trump development. Thank you.
Thank you very much. Thank you, Nimita. I'll hand the word to Tatiana Alfonso from CIDE in Mexico City and LawTransform. Tatiana.
Yeah. Thank you, Rachel. Thank you, Siri, Lara, and all the people that makes this possible. And thank you all for the energy to be here again. So I'm going to talk about the case of Colombia, which is the one that I have been working on for this project and for a long time. And I'm just going to say a couple of things about the context and why Colombia is quite a case for this kind of reflection. And also, I'm just going to tell you what I have been analyzing regarding land claims from basically 3 groups of population, as Rachel said: Indigenous communities, Black communities, which is the name that Afro-descendants communities get in the legal legislation of Colombia, and peasants, which is where I have them. I don't know if the most interesting findings, but the most novel for the Colombian context at least. So that's what I like to share with you today. And I'm gonna present a little bit the theoretical framework that we have worked, and that it's in this article for the annual review of law and social science that Rachel mentioned, because it's very important to understand how much transformation we're getting or not through courts and judicialization, right? So the first thing that I'd say is that Colombia, as probably many of you know, is a laboratory for so many things. not exactly good things, but for so many things, right? War, inequality, poverty, and then also happy people and all that, those stereotypes. But in terms of land and land regimes, it's also a very particular context, because as Colombia has gone through different waves of violence, and it's a country that is full of lawyers, mea culpa too, right? It deals a lot, it aims to deal a lot with the problems through law. So we have different waves of legislation, and land is one of the crucial elements of the Colombian conflict historically, right? So what we've seen is like different waves of legislation that try to deal with different problems along time. So we had a failed land reform in the 60s, as so many other countries in Latin America went through. Colombia didn't have any success in land reform, so but that's a law that's still in place, which was supposed to be agrarian law, but it's actually civil law for property acquisition of individual titles. And then, so we had a reform of that with the Constitution of 1991. Well, not exactly a reform, but a nuance, because the Colombian Constitution includes clause of the social function of property, which means that nobody is supposed to have land if they are not using it. So it was supposed to protect people from dispossession, but also to foster agrarian development. None of those happened. And actually, Colombia by 1994 showed the highest levels of concentration of land in a few hands. And that's still the case for most part. But also, I mean, it's a very disorganized context, because after even that reform, then the Colombian conflict didn't get better, as you know, after the constitution, but got worsened. So we still have different actors, but at that point, after the 1991 constitution, so we had the guerrillas that didn't go through the peace process, and then we had like a reloaded version of the original paramilitaries, and also like small armed actors in the territories, and the communities and people in the middle, right? So after 1994, with a new reform of the agrarian law, which was actual civil law, we had 10 years of the same legislation that in theory was allocating land for peasants, but that actually didn't happen because it was intervened by the logics of the conflict. So instead of having like peasants with land, as the law pretended or aimed, so we had like landowners, like big landowners, right? And then in 2005, we had the process of demobilization of paramilitaries, which was supposed to create new opportunities for land allocation for peasants. That didn't happen, but after several years of that, we did, I mean, I don't know if it was an achievement, the law of restitution, of land restitution. It's called Law of Victims and Land Restitution. It was a huge political battle, so the law passed, and it's very progressive, it has a lot of protections for peasants. It didn't have any consideration of indigenous peoples and black communities by that time. This was in 2011. Because I omitted that, of course, in the 1991 constitution, the important thing is that, well, for this argument, is that peasants were left out because they were associated with the FARC, with the guerrilla in the leftists that didn't go through the peace process, whereas indigenous communities and black communities entered into the constitution through the multicultural clauses. So they are considered ethnic groups with special and differentiated rights over land. So those are collective land rights. And it's called collective property. And it's only for indigenous communities and black communities, right? So it's not for anyone else, which means that it's clearly associated with an identity that people need to claim and assert, and the state challenges all the time. And they have a special procedure, so they don't go, in order to acquire land, they don't go through the civil law or through the agrarian law. So in 2011, we had the Victims and Land Restitution Law, which started to work and created a new jurisdiction, which is the restitution jurisdiction. And then you could have peasants, indigenous, or black communities to use the law, because all of them have been victims of the conflict. And then after the last peace process with the FARC in 2016, so we have new regimes for land allocation and land acquisition, which are supposed to be more agrarian. So what we have been doing, what I have been doing in Colombia is I have been analyzing the evolution of judicialized land conflicts before the Constitutional Court between 1991 and 2022. So at the beginning I had 1,000 cases, 1,014 cases. So I started to clean the database, and I'm working now with 176 cases of rural claims, in which the court adjudicate the rights for rural communities, and I have been qualifying those claims according to the frames that they use, the type of law that they use and the type of category that they use. So I think about them as proxies of social legal mobilization, as constitutional frames are used for the analysis of the emergence and changes of political identities for land claims, because as I said, those are really associated in the context, and you have different data, like baselines for thinking about distribution and transformation in those cases. So I basically am trying to differentiate the dynamics between claims and responses in three elements: political identity, legal regime over land, and the potential distributive impact of the judicial decision. So those are the things that I'm qualifying. And what I have been finding is that after the constitutional reform, the plurality of legal regimes in the Colombian context created several waves of recognition of ethnic identities, indigenous and black communities, at the expense of peasants as political actors and as subjects of the right to land. So I argued that the co-evolution of political identities, land regime, and distributive conflicts at the national level shape the shifting margins of structures of legal opportunities for judicial claims of rural life in Colombia. And in terms of transformation, which we are saying that we're working with Fraser's theoretical framework, but not with the classic duality between the symbolic and the structural injustice, but with the remedies. So thinking about affirmative versus transformative remedies is what we're saying that we need to look at. And for the cases of Colombia, what I'm seeing in the empirical analysis is that the type of remedy that is providing more opportunities for transformation compared to the injustice that different groups were facing before going to court, because the use of the court in Colombia is very common, and it's one of the primary repertoires, is the collective path. So when peasants are claiming collective property over land, they are getting better institutional arrangements for them to have the land, control the land, and manage the resources in them. And I'm over. I'm done. I'm on time now.
Thank you so much, Tatiana. 8 minutes, Colombia political history. So it's very impressive. Very impressive. I'm going to hand over to Ana Carolina Alfinito, who is part of PluriLand and also works for Amazon Watch and is at the Federal University of Pará in Brazil. So, Ana Carolina, thank you.
So, thank you, everyone. Thank you, Siri. Thank you, Lara, for the organization, for the invitation. Thank you, Rachel, for the invitation to be part of PluriLand, where it's been very, very helpful and very important for the research that I've been doing. So I'm the newest member of this research project, and now I see how much convergence there is between our research. I'm very excited. So I think in terms of context, so I've been thinking about how, to put the research that I've been doing in kind of productive dialogue with every kind of things that I've been hearing here throughout the week, and about all this research in courts and democracy, autocratization. So I think I really want to start by saying that debates over extractivism and land rights in Brazil, they're not at the margin of political discussions, of political debates and contention. They're very much at the center. And I think it's very difficult for us to fully understand authoritarianism and the far right in Brazil today, and maybe in Latin America, but that's too much of an argument for me. But in Brazil, without looking at extractive dynamics and without looking at debates over identities, over territories, over land. This is at the center of the far right's project. It was at the center of our previous administration. It's still at the center of what's been going on in Congress and in the territory. So I want to bring this debate really to the core of thinking about democracy and autocracies. I think, access to natural resources. Deciding which territories are available to resource extraction is not really a democratic business. It has not been very democratic in the countries where we're from. And so I'm looking at a specific territory, so I'm going to speak from a very territorial lens. So it's very difficult for me to speak without maps, but I'm going to try. And I also want to say that in my research, I've been trying to look at this vertical aspect of the law, whereas the law to the land interacts and conflicts with the law of the underground, which is mining law, which is very autocratic. It's amazingly autocratic. I mean, basically, if you have any rights to the soil and somebody wants to mine underneath where you are, you can be very concerned because your rights will be unprotected, restricted. The chances that you'll be removed from your land are very high. So there's an autocratic component and this reason of state component and the sovereignty to the underground, which is still very much alive in so many legal systems. And when we pit this against all these plural land, it's one more thing that we have to think about when we think about plurilands. And in Brazil, there's a whole discussion today about legal pluralism and territorial rights, but also the social function of the underground and geopluralities, so the plurality of ways in which people deal with the whole structure of geologic structure. It's not only about the soil. So these are important things that I want to just signal here. And so I've been looking at the specific territory that's called the Big Bend of the Xingu River. It's in the Brazilian Amazon in the state of Pará. It's a place that's been very impacted by energy extraction and extractivism. So a big hydropower dam was constructed there, Belo Monte. And today there's a big gold mining frontier that's being opened in this territory. A transnational Canadian mining company is trying to open up a massive gold mining project. And the Big Bend of the Xingu River, it's called the Big Bend because the river is actually flowing down to the Amazon and then it goes like this. So it's a place of a flood pulse. It's a very singular ecosystem. And it's a place of a constellation of communities and of people. So there are indigenous peoples from 3 different linguistic families in Brazil. There are hundreds of fishing communities, traditional communities. There are hundreds of peasant families as well. So you have this encounter of different forms of territories, different territories, and also of different legal regimes that are attributed to these different kind of codified identities. So you have indigenous peoples living side by side to traditional groups, living side by side to peasant communities within land reform settlement, and they're all going to be impacted by this mining project. And there's a big question of, well, what rights do these people have? They're neighbors. They're all neighbors, but the law attributes to them different bundles of rights. So you have indigenous peoples with free, prior, and informed consent, consultation and consent. Their lands are protected from extractivism, even from mineral extractivism in Brazil. They're the last mining-free territories of Brazil today. And then on the other hand, you have agrarian communities which have basically no rights. They're very unprotected under Brazilian and even under international law. And so my research question has been really looking at these different legal regimes and different forms of using the territory and the land. How has litigation concerning this mining project affected the construction of this territory? Understanding a territory as a relational process, that's really built through the distribution also of power amongst these communities. And litigation has been about who can decide how this land will be used, who will have access to it. You know, who actually will have voice and decision-making power about whether extractivism will happen or not in the Volta Grande do Xingu. So I've been looking at litigation processes in a longitudinal perspective. So that's something that I think is really important. So Namita has said, you know, there are lawsuits that take 20 years to be decided. Well, it's not only after 20 years that these lawsuits are going to impact the territory, right? When you have one preliminary injunction saying, oh, the mining company has requested that this community be evicted, the preliminary injunction, which will happen in 2 weeks, is crucial to that territory, because that preliminary injunction may be in place for years until a final decision is made. So I've been taking on this really longitudinal kind of approach to decision, how it's responded to, how it's implemented, decision, response, implementation, feeding back to decision, looking at 12 different legal suits, litigation processes, concerning mostly FPIC, free, prior, and informed consent, of these different kind of legal categories and legal groups. 2 minutes, that's fine. And so to really try to bring this notion of territory into the study of litigation and see how I can operationalize the impacts of legal decisions and their implementation on who gets to control, to use, and decide what goes on in the land. So what have been some of my preliminary findings? When we think about the transformative potential of litigation, I've tried to take on this kind of imminent approach to what this potential is. And imminent here meaning what legal operators and communities have actually demanded through the law. And so what have they demanded? They have demanded the right to full consent or veto of the project for the indigenous groups. There are 19 indigenous communities, for the hundreds of riverine fishing communities, and for the agrarian reform settlements and the peasant families that are right under where the mine is going to be. So this is what the potential here is, that everyone here can say whether this mine will happen or will not happen. Full political and kind of self-determination rights for these groups. Has litigation lived up to this potential? No way. No way. Unfortunately not. So in the decisions, courts have found that peasant communities do not have free, prior, informed consent rights because they're not tribal, they're not indigenous, they're not traditional, but they are traditional communities. They're traditional forest extractive communities, but the courts have not understood them this way, at least in the preliminary injunction. The fishing communities as well, and they don't have this right. And the indigenous communities only have the right if they live within an 8-kilometer radius of the mine, which makes absolutely no sense, because we know that big mines up to 70 kilometers of distance, they will foster deforestation, et cetera. So what happened was there's a stratification of communities. This legal decision has led to stratification between neighbors. Some have more rights, some have less rights. In the second place, it has led to a slowing down of the pace of extractivism. So licensing has been going on for 12 years now, and the project has not begun. So law changes the time. And third and finally, an interesting territorial process is that the communities that were not included in FPIC and in the licensing process, they know they will be affected. Of course, they know they will be affected. And so they're moving closer to the project to try to get their existence recognized and their identity recognized and to be included in FPIC. So it's like going after the impacts instead of moving away from the impacts.
Wonderful. Thank you so much, Ana. Our final presenter is Jorge Peláez Padilla from the Universidad Iberoamericana in Mexico City. Jorge, thank you.
Thank you. First, I want to thank Siri, Lara, and Rachel for the opportunity to discuss my work with PluriLand project. But then I'm going to start for the time. I would like to share some preliminary findings from a research project developed in collaboration with Tatiana Alfonso as part of the broader initiative titled Law in Motion, Trajectories and Effect of Judicialization of Socio-Environmental Conflict in Mexico. In this specific segment of the project, we focus on analyzing the effects of what we call environmentalization of legal mobilization by indigenous peoples in Mexico in defense of their lands and territories. By environmentalizations, we refer the growing use of environmental language, frameworks, and rights in legal strategies. What we are trying to understand is whether this shift in legal framing is producing different outcomes in the courts, whether they are more favorable, more affirmative, or even transformative, using, for this, the theoretical framework developed by PluriLand project. Well, the context of the problem. Mm-hmm. To understand the current dynamics, it's important to clarify that the core problem indigenous people face today in terms of land in Mexico is not landlessness or lack of title. Following the Mexican Revolution and the agrarian reform process, many indigenous communities were granted formal recognition of their pre-existing land rights. This happened throughout two collective property regimes. First, the communal property for indigenous people that have had previous title, and ejido, propiedad ejidal, for those peoples that doesn't have a title before the Mexican Revolution. And so today's struggles are not about obtaining land or security ownership, but about defending those land against dispossession, often throughout development or investment project imposed without consent, a mining project or fracking project or something like that. There are also long-standing issues related to unresolved land boundaries from the agrarian reform, but that is beyond the scope of this presentation. What we are seeing in recent years is a clear shift. Indigenous struggles of land and territory are increasingly framed in environmental terms. And this raises a key research question. That is the question of this part of the research. When indigenous community frame their legal claims as environmental, rather than just as territorial or autonomy basis, does that change the outcome? This is the theoretical framework. We build on theoretical contribution development with PluriLand, as I told before. But one thing that is important is how we define socio-environmental conflict. That is the kind of conflict that we are registering in the database. And we define as confrontations between two or more actors, whether individual or collective, in which environmental is at the core of the dispute. It use, access, conservation, destruction, commodification, or meaning. These are not merely resource disputes, but conflict over the social and environmental consequence of resource use and transformation. This is the core. These conceptual lens allow us to analyze litigation not simple as a legal event, but as a part of broader political struggle where the law is also a terrain of contestation. To investigate this question, we create a data set that is part of the broader database of judicialized socio-environmental conflicts in Mexico. We focus on legal cases involving human rights claims, including amparo, lawsuit, constitutional controversies, action on unconstitutionality, and collective action. That is a kind of civil procedure in Mexico. We look at levels of it is important, of the federal judiciary, not just the Supreme Court. That is one of the main or the more important things in the project. Our time frame spans from 2011, the year of Mexico constitutional human rights reform, throughout the present. This allows us to analyze outcomes both in the short term across different public administrations, and in the longer term, including during the so-called fourth transformation and the ongoing judicial reform process that it's happened now in Mexico. In this, we identify cases throughout multiple sources. First, the CISE search engine for federal judicial district and circuit, that it was very complicated in Mexico. The Supreme Court database, records from human rights organizations, and inside draw from over 50 years of direct involvement in indigenous legal process and research. I have some challenges with the data access, but I think that for the time I'm going to define it.
2 minutes.
Yes. What we have so far, despite all challenges with the data, we built a working database of 2,088 judicial cases, of which 49 involve indigenous, original, or Afro-Mexican peoples or communities. So far, our data covers rulings issued between 2019 and 2024. We are still in the process of reviewing early cases from 2011 and 2018, but we anticipate that the number will be lower, since the environmentalization trend is very recent. On the first major cases that marked this shift was the Yaqui Trip versus Independence Aqueduct, filed in 2010 and resolved by the Supreme Court in 2012. Well, what is the preliminary finding that after this? Based on our first review of the data, we identified two main patterns. First, cases where the legal framing centers on environmental arguments tend to produce more favorable outcomes than those based solely on claims to territory, autonomy, or indigenous self-determinations. Second, even when rulings are favorable, when an amparo is granted, for example, the remedies tend to be affirmative but not transformative. What do we mean by that? Courts often acknowledge that the right was violated. It's okay, usually by recognizing environmental harm to indigenous lands or territory. But rather than canceling the imposed project, courts typically offer procedural remedies. For example, reopening the consultation process or requiring new permits for the projects. It's okay.
Thank you. Thank you, Jorge. I'm sorry to cut you off, but we have 10 minutes for audience questions and participation. So okay, thank you, everybody, for wonderful questions. We have 1 minute, not even 1 minute each, but let's try and do 1 minute each. I don't think we can answer all of them, but just I'll take my 1 minute to say, Daniela, yes, we've been kind of, as Tatiana said, working with phrases, recognition, redistribution, symbolic and material violences, and trying to think through kind of this distinction between affirmative and transformative, which you can read the article about. The other thing to say is that we're all really interested in the ways in which, litigation as a strategy of protection in some cases as well, but is about placing alternative narratives to a greater or lesser extent successful, but alternative narratives of thinking about territory in the public sphere. And kind of speaking to Andrew, yeah, I mean, territory is not land, but land is how, and property rights is how colonial states have historically thought about territory. So this is a site of epistemological difference. And then the question coming to Swati is kind of what traction, like what are the effects of that, not just in terms of the remedies of the courts, but the socio-legal process of mobilization in terms of organization and community life world. So lots to say about that, but I'm going to stop. I think that's my 1 minute, and hand to Tatiana. Yeah? Oh, sorry, Namita.
No, maybe
Sorry.
then I'm gonna take my minute just to add to that and to Daniel's, to respond to Daniel's, is that we have created baselines for each of the cases to identify the type of injustice that you see in each of them in all of the cases, and I think that's one of our arguments about what's specific about land in terms of litigation and distribution of resources, is that land disposition in Latin America is a typical case of what Fraser has called bivalent injustice, which combines symbolic and structural, right? So in each of the cases, we are coding or identifying with historical information and sociological information what are the injustices and how they are characterized in each of the contexts. And then what we came up with in this analytical model is that instead of dealing with is this remedy symbolic or structural, which, like it's a duality that you cannot overcome, then you could identify the process and the steps in which you have different decisions and remedies as necessary and or sufficient conditions for getting something changed compared to that baseline. So then we have measures of protection, restitution, et cetera, et cetera. So we basically are giving values, right, to all that information and the type of injustice, and seeing if the court and the process of judicialization is reverting something of that or not, right? So, for example, free FPIC. It's incredible that I forget how
Free,
to.
hire, and inform.
It's incredible. I've been doing for 20 years. FPIC, which is usually characterized as not enough, for some people, or we won because we won the case. In our analytical project, it is a necessary condition for a transformative remedy. If you don't have, why? Because historically, most of the communities in Latin America, and in our cases, had gone through FPIC because it's the only tool that the legal system provided, right, in order to open claims for self-determination and autonomy. So, right, and then, we have a 2x2 table, which is nice if you want to see it. You're gonna look at it.
Thanks, Fatima. Amita?
Thank you. So I just want to say quickly a word about the 4 cases. So the 2 dam cases are dams on the Narmada River. The mining case, one is the Samata case from Andhra Pradesh, and the other one is Vedanta. I also want to say that actually we started out together thinking of like sites and frames, and so I picked the Supreme Court as the site where because we have plural legal regimes in the federal and the state level and so on, to see how different claims were being articulated, and there were hundreds of cases, and then I sort of narrowed it down to the 4 cases that I have, because the question that I was trying to address is that under what conditions does social legal mobilization of this kind succeed? And just to say that the cases from the origin of the legal dispute to the resolution 40 to 70 years, in the Indian context, these cases are transformative, Danieli, because each of these cases actually resulted in a change, not just in the domestic law, but for example, and it led to the passing of legislation, whether it was the Forest Rights Act, or whether it was, and I'm not saying that it was only an effect of the cases, but the cases did contribute a lot to the social movements mobilizing for this very progressive legislation that India enacted, the Right to Fair Compensation and Transparency, Land Acquisition, Rehabilitation, Resettlement Act. The whole idea of rehabilitation came from the Narmada Bachao cases. And they're interesting because in one case, the dam was constructed, and in another case, the dam was never constructed. And yet, even in the case that the dam was constructed, the community is regarded as a success because it allowed them 25 years to figure out their options. And Swati, in response to your question, I don't know about the impacts, severe impacts for the communities that did get displaced, but the mobilization and the movement had a very positive gender impact, because just like Gandhiji brought women into women who had been within the family out into the independence movement. Similarly here, women were at the forefront of the resistance against the projects. And lastly, to violence, what we find is that the violence is getting extreme over time. So the Samata case from the 90s or the Narmada Bachao cases, violence is more about the police just arresting people and putting them in jail. But we see a greater fusion of the private and the state machinery in the Vedanta case, which comes from the 2010. And that case is particularly significant because it raised a higher standard of free prior informed consent, more than what the international standard demanded at that time. Thank you.
Thank you. I'm sorry, but we're out of time. So in good LawTransform tradition, please interrogate everybody over a cup of tea or coffee in the break. And thank you all very much.
Thank you.